I reserve my right to.
जी, हम यही आपको कह रहे हैं कि आपको यकीनन मौका देंगे.
And I have done that in my CMA 8252 of 2023.
जी, तो अगर किसी और को कोई इस पे एतराज नहीं है तो अटॉर्नी जनरल आगाज कर सकते हैं. एक शख्स एक वक्त में आके स्पीकर के सामने बात करें, दूसरे शख्स जरा जगह दे दें.
योर ऑनर, मैं कार्रवाई शुरू होने से पहले गुजारिश करना चाहता हूँ.
माइक में बात कीजिए.
योर ऑनर, मैं कार्रवाई शुरू होने से पहले गुजारिश करना चाहता हूँ. आई हैव चैलेंज दी सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट, और जो बिल चैलेंज हुआ इन दोनों को मैं अलग समझता हूँ, क्योंकि बिल जो है उसको चैलेंज करना.
अभी हम सिर्फ पूछ रहे हैं आपको इतराज है, अटॉर्नी जनरल आगाज करें बात का, हाँ या ना. सवाल आपने नहीं सुना था.
हाँ सर वो कर ले
तो फिर बस ठीक है, यही पूछा ना. अभी और आप बहस ना कीजिए ना. अगर आप कुछ कहना चाहते हैं कि आपको इतराज है उनके बहस करने से, तो फिर हम आपको पहले सुन लेते हैं.
नहीं, वन लाइन में अर्ज करना चाह रहा हूँ कि ये बिल को अगर उसको अलग सुनिए.
दोबारा आपने बात शुरू कर दी वही.
My lord, if I may, my lord, I have to argue if Attorney General may be requested to argue after all the petitioners have argued their point of view. I think then we can.
आप किधर से हैं?
My lord, I am for 19. My lord, I was not here last time. I was abroad, so.
तो आपने उसको अहमियत नहीं दी.
No, my lord, actually I was already traveling. It was fixed on a Saturday, so my lord.
आप किसके लिए हैं?
My lord, petitions.
नाम बताइए किसके लिए.
Mudassir Hassan, my lord.
कौन है मुदस्सिर हसन?
He is a lawyer, my lord. He is a petitioner.
किधर है, दिखाएं उनको.
My lord, today he has, my lord, called to Peshawar. He has a case in Peshawar.
हाँ, तो देखिए ये तो अहमियत आप दे रहे हैं. एक दिन वकील नहीं है तो दूसरे दिन वो पिटिशनर, इनको जितना शौक इस केस का नहीं है.
This was fixed.
आप कितना वक्त लेंगे?
My lord, maybe at your lordship's discretion, half an hour to 30 to 60 minutes, my lord.
नहीं,
very
नहीं, मुख्तसर. हाफ एन आवर वाले इतने लंबे नहीं है. मुख्तसर बात कर लें तो कर लें.
My lord, I would.
अच्छा, आप करना चाहते हैं. और पिटिशनर की तरफ से कौन है?
Of the same submission, I have a petition number 33.
अगर आप प्लीज बता दें, आप पहले सुनना चाहते हैं अटॉर्नी जनरल को ना?
If I am allowed to argue first, my lord.
अच्छा ठीक है, कर लेते हैं. चलें, आ जाइए. आप जी चौधरी साहब बताइए.
CP20 सर.
नहीं, आप पहले बहस करना चाहते हैं?
मैं कुछ
अच्छा, आप किसके लिए किसके लिए हैं? आप किसके लिए हैं?
न्याजुल्लाह न्याजी पेटिशनर है, मौजूद है.
कौन है? वकील हैं?
He is an advocate and former president of the Islamabad High
चलो, आप सीनियर हैं, आप बताइए आपका केस नंबर क्या है?
CP20 में.
CP20.
I've already filed concise statement, my lord. And
ठीक.
concise statement.
20 एक से इनकी निकालने पिटिशन.
Concise statement is 8279, my lord.
CP20.
ये जी.
Lord, if I'm permitted,
My lord, if I may.
प्लीज.
Lord, I will just be reading the Act 17, my lord, before I submit my.
चौधरी साहब, अब आप पूरा ना पढ़िए, हम पूरा एक्ट पढ़ चुके हैं. उसका अगर आप एक शिक पढ़ना चाहें, उसको बहस करना चाहें तो कर दीजिए.
मैं उसी तरफ आ रहा हूँ सर, मैं उसी तरफ आ रहा हूँ. सबसे पहले तो इसका जो ओपनिंग पैरा है, अगर इजाजत दे, क्योंकि वो क्रक्स है उस सारे इशू का जो बुनियादी तौर पे इस एक्ट का हिस्सा है. तो आई वुड, मे आई माय लॉर्ड.
बिस्मिल्लाह कर लीजिए, शुरू कीजिए.
Whereas Article 191 of the Constitution provides that subject to the Constitution and law, the Supreme Court may make rules regulating the practice and procedure of the Supreme Court. And whereas Article 10A of the Constitution mandated right to fair trial and due process, Article 4 of the Constitution guarantees treatment in accordance with law, and Article 25 of the Constitution prohibits discriminatory treatment, and right of appeal is a universal fundamental principle of jurisprudence.
Please.
And Islam guarantees right to appeal, therefore, pursuant of Article 175(2) read with Article 191 of the Constitution, the law is being enacted. And whereas it is expedient to make law providing for certain practices and procedures of the Supreme Court, my respectful submission is, this para, as a matter of fact, indicates that this law is being enacted for a certain purpose, maybe for specific purpose, and I may say person specific, purpose specific, and maybe time specific as well. Very respectfully, if I am permitted.
You are implying words in it, or does it say so?
Lord, it says so, it means it.
Where it is say so, it's for a person.
Now,
Let's not introduce words in a statute which don't exist. If that is your impression, say it, that is my impression.
that is my impression.
So the law doesn't say this.
Lord. So, all the sections which are part of this Act 17 of 2023, I would go to Section 3. Any matter invoking exercise of original jurisdiction under Article 184(3) of the Constitution shall be first placed before the committee constituted under Section 2 for examination, and if the committee of the opinion that a question of public importance with reference to enforcement of any of the fundamental rights conferred by Chapter 1, Part 2 of the Constitution is involved, it shall constitute a bench comprising not less than 3 judges of the Supreme Court of Pakistan, which may also include the members of the committee for adjudication of the matter. Regarding this Section 3, my submission is basically the legal authority already being part of the 1980 rules, Supreme Court rules. This section, as a matter of fact, has been introduced by the Parliament, and I would respectfully say this is an encroachment on the area which falls within the jurisdiction, within the legal framework, I must say. So this is being in conflict with the separation of power theory. My submission is this conflicts, and this is ultra vires, my lord, so far as this Section 3 is concerned, my lord. Lord, then regarding appeal, Section 5 I will read. An appeal shall lie within 30 days from the order of the bench exercising jurisdiction under Clause 3 of Article 184 of the Constitution to a larger bench of the Supreme Court. Of such appeal shall be within a period not exceeding 14 days to be fixed for hearing. The right of appeal under subsection 1 shall also be available to an aggrieved person against whom an order has been made under Clause 3 of 184 of the Constitution prior to the commencement of the Act, provided that appeal under subsection shall be filed within 30 days of the commencement of the Act. This appeal has been provided in Article 184(3). My submission is this could have been done only if the Parliament had 2/3 majority, so this falls within the area of constitutional, I must say, competence of the legislature. So this is ultra vires the Constitution, so far as Section 5 is concerned, until and unless there is 2/3 majority in the Parliament, this addition in 184(3) could not be done, and therefore this is against the separation theory as well as against the Article 239 of the Constitution wherein 2/3 majority is a constitutional requirement for amendment in the Constitution. This encroaches upon the area I have just referred to. Regarding 6, my lord, I will just submit that the counsel which this is regarding review, the counsel who would be conducting a case before the Honorable Court would be most suitable for the purpose of arguing the case while review is filed by a party. My lord, overriding of all laws, Section 8 I would read. The provision of this act shall have effect notwithstanding anything contained in any other law, rules or regulations of the time for the time being in force or judgment of the court, including the Supreme Court and a High Court. Lord, my submission is the provision has bulldozed the independence of judiciary concept provided, and which has been established, my lord, by law, Constitution, as well as the President of this Honorable Court. So my submission is the total effort by enacting this law, which I am just referring to, effort has been made to enter into the area which is not within the domain of the Parliament, my lord. One thing I would be very respectfully submitting, that in parliamentary system, as a matter of fact, Parliament and the executive, they are the one. I must say, they are the same phenomena in the Constitution. They have a nexus amongst themselves. So therefore, I would say, and this has been so, I'll be just reading a line from my paper book, the condition which was prevailing at the time when this act was being, whether it was discussed, it is a question again, but when it was being passed by the Parliament, certain observations which have been reported in the press, that is very relevant for the purpose of understanding how this enactment was done and passed by the truncated Parliament, I must say, because it was not a Parliament indeed which had to go into the amendment of the Constitution. They had no authority to do so. I may just be allowed for a minute. Constitution petition 20 and page, my lord, I just read it for your.
Are you finding basing your arguments on the basis of news reports in the Constitutional Court before the full court?
We don't have the.
You can't articulate the same thing yourself. As senior counsel, you have to rely upon a news item,
No, my lord.
which may or may not be true.
My lord, very respectfully submitted. We don't have the record of the proceedings of the Parliament, my lord. A question arose in certain proceedings before this Honorable Court in another case, and I think we submitted him even
One second.
on the last date of
Please
hearing.
don't travel outside the domain of this court. If you wanted something, the record of the Parliament, did you write to the Speaker?
We spoke-
Whether he would allow your request or not is a separate thing.
Lord, it's not
Did
me.
you write to the Speaker?
No, my lord, it's not me. As a matter of fact, we requested your lordships to.
I'm
summon
asking
the
you a simple
record
question.
of
You didn't
the
write to the Speaker.
My lord,
We are a separate constitutional body. Parliament is a separate constitutional body. Okay? If you want some information from the Supreme Court, for instance, would you write to the National Assembly Speaker? You would write to the registrar of this court. Similarly, if you want some information from the Supreme Court, Parliament, whether they give it or not would be a separate matter. Freedom of Information Act 19A has now become part of the Constitution. If you don't bother to say, avail of this opportunity, please don't take this ground before us.
But I
Because
was-
it's a hollow ground. You haven't built on the ground yet.
Lord, certain records which are publicly available, and there is no reason to doubt them. So I think at times we have been referring these some of the news items for the purpose of understanding as to how certain acts or certain legal proceedings were taken. My lord,
Please, we will hear you, but we will not hear arguments of this nature. When you say, I will not write a simple letter and I will take up the time of the entire Supreme Court to articulate a proposition which has no factual basis.
One thing I
So
must
please
say,
argue your own case. Forget
My lord,
what the newspapers say. You argue your case.
my lord, this is not my case, it's not an individual's case, this is case of the whole nation, as a matter of fact, which is before your lordships. So therefore, certain items.
Please, again
which
you
may be relevant for-
have assumed yourself, देखिए ये ना कीजिए. Hazur, you have assumed yourself the representative of the nation. Sorry, you are not. You are a petitioner before us. Argue your case.
My lord,
We don't assume to speak for the nation, nor can you speak for the
My
nation.
lord, 184(3) proceedings, as a matter of fact, are meant for two important things. One, matter of public importance, and then breach of fundamental rights for that matter and its enforcement. So this is, I must say, this is relevant in any case at par. If you just permit me just one line, because it's very relevant. Ex-Prime Minister wants National Assembly to summon CJP, Chief Justice of Pakistan. I must say very respectfully, this.
Please do not say anything. That list is not before us. And you've not made the person a party. You cannot make allegations against somebody without making him a party or her a party. Please, we will not permit this.
Right, my lord.
You can't use this forum as for a political debate. The media is available to you. You can go and give a talk on the media.
Lord, I am before your lordships on law and constitution. So therefore, my respectful submission is certain relevant facts which are admitted and publicly known. They are relevant because the proceedings in
Please
this
tell us what are those.
many years ki, now your lordship may permit me, we had an assembly of lot of people right out on the Constitution Avenue. This is a background, my lord, in which this enactment was being passed by the assembly, and they had encroached upon the area which is within the ambit of your lordship, that is the judiciary. So that is why
ये point argue कीजिए ना कि पार्लियामान ने सुप्रीम कोर्ट के इख्तियारात सलब किए. ये कानूनी दलाइल दीजिए ना.